Thank you. Oh God, I was told this would go on. I just didn't realize that I could hear myself so easily. What I thought I would do, if it's acceptable, is that I would first of all say thank you to Ali for inviting me. And I then discovered to my chagrin that it's Wisdom Wednesday, which means what? That this is oxymoronic. My talking to you on Wisdom Wednesday is, the only way I could actually fulfill the criteria, I guess, for wisdom would be, do you remember Kansas, the rock group Kansas? And they had a song called Wayward Son, appropriately. And there's a line in it which says, if I claim to be a wise man, it means I surely do not know. That's the only way I'm going to be able to pull this off. What I thought I would do is go through that outline, which I hope would be helpful in order to follow this. And because it's so topical and present, I thought perhaps that with these, and my correction of some of the mistakes in it, I could show you, or I could do this, that I could infect you with the same amount of confusion that I have. That you would walk out of here saying, I don't know what the hell just happened in there, but it would be different from the confusion you might have if you just read Article 2, Section 2, Clause 1. So let me start off with, I think what I'll do is, because of the time, my thinking now is that I can do the introduction, I know that sounds odd, do the introduction on the second half of the page, the other side of the page, which would be more appropriate. So what I thought I would do is, you have those appropriate areas of the Constitution in your possession. And what I will do is reference it if I have to, or if you think I'm cheating in this presentation. So I think Article 1, Section 2, Clause 5 says that if you want to impeach any federal officer, that impeachment must be approved by the majority of the House of Representatives. The House of Representatives. And that's only to what? The House of Representatives serves in some ways as a probable cause hearing. They're just finding probable cause to hold the party over for a trial of sorts by the U.S. Senate. The U.S. Senate can actually convict the impeached party in this impeachment trial pursuant to Article 1, Section 3, Clause 6, if they can garner 2/3 vote of those present. What's odd about that is that you cannot look at this as for instance, a jury trial in a criminal case. Because if the jury trial would require a unanimous vote for conviction, you'd also need a unanimous vote for acquittal. Otherwise, you'd just get a hung jury. And since a hung jury is manifest necessity, the defendant will find him or herself before a trial again. But here, 2/3 to convict, and if you don't get 2/3, you're acquitted, so to speak. So that makes the Senate trial, not that it's supposed to follow Article 3, but that the Senate trial is different from a judicial trial. Does that seem, just nod at me or do something so that you don't start to resemble my students, like I put you in a coma. So if you look at, interestingly, if you look at Article 1, Section 3, Clause 4, that should be 4, not 6, then it says the Vice President is the President of the U.S. Senate. Well, let me see if I've got this right. The conviction occurs in the Senate. The trial occurs in the Senate. And who runs the Senate? The Vice President of the United States. That's one of those checks and balances that the framers had the wisdom to foresee. But notice also here that when the chief executive, who the heck is that? I think it's the president, right? The president is the chief executive, right? When the chief executive is impeached, the Chief Justice of the United States Supreme Court presides. Why? Why would they do that? Pardon?
I don't think the vice president could be neutral.
No, and that's exactly right, Mary. The vice president wouldn't be neutral. The vice president would be saying, well, let's see, if I really want this job. Good grief. I think everything he's done or she's done is convictable, right? Everything they've done is wrong. I assume that neutral magistrate would be biased, tendentious, prejudiced, right? Yes?
What would they do if it's the vice president who's being impeached?
My very next question. But you know what? There's nothing in the United States Constitution that tells me who presides over the vice president. Hence, we have our first principle that helps us through this. And it's called, colloquially, the greater lesser principle. That is, the greater power that you enjoy, you also enjoy a lesser power that falls within it. Correct? If you have a greater power, or if you have a greater inhibiting barrier, then, and a lesser inhibiting barrier, then a greater inhibiting barrier would stop you also. Does that sound reasonable? Remember, you were not going to resemble students, you were going to, it's like nod at me or something. So for instance, if the vice president does not sit in the Senate trial over the president because of bias, how would the vice president look when the vice president is being impeached, being tried? Would the vice president be perhaps more biased about his or her own trial based on impeachment? I don't have to answer the question then. The Constitution already did it. It already answered it. But notice, I couldn't have gleaned that by just reading the Constitution. Constitution tells me lots of things, but it doesn't tell me how to read it. I know that sounds odd, but it really doesn't. I have to figure out, what am I supposed to do with this list of things? Is that the end of the list, or is that just the beginning of it? I won't know that. I'll have to go outside the Constitution to bring this in. And I would have to do it here with that the greater lesser principle you won't find in the Constitution. I've looked. I couldn't find it. So the next one, the last one is and I have it there, the lesser greater, greater lesser. In that case, it would be the lesser greater. In Article 3, Section 7, a very important section, impeachment with conviction results only in the removal from office. If you get convicted in the U.S. Senate, that's the only thing they're going to do is remove you from the office itself. Nothing more. That's all they can do. Which is one of the reasons I take it that's the ultimate, I don't mean in importance, but then the sequentially ultimate punishment is you get thrown out of office. But does that mean that when you're tossed out of office, you've been impeached and convicted, right? Does that mean that you cannot be now pursued criminally? No, it does not mean that. In fact, the rest of Article 1, Section 3, Clause 7 says, but the party convicted, that means senatorially convicted, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment. Now, a very good exercise is, that's the only way that could happen? Do you have to be impeached? Or it just means you can't be in office? I think, right, President Ford assumed, and rightly so, that it was just that you're out of office. Whether you voluntarily left office or whether you were impeached and convicted and booted out of office, you could then be criminally prosecuted. Otherwise, President Ford would have had, what, no reason to pardon President Nixon, because, well, hell, if I took that literally, you wouldn't be able to do it because he wasn't impeached and convicted first. Right, notice also that although the ultimate result of impeachment and conviction is to be jettisoned from the office, does that mean you couldn't impeach and convict even if the party had left? Could the United States people say, don't stop, Senate and House, I want you to try and impeach Nixon and try him. Oh, I know he left office, so we won't do anything but what? I take it that Richard Nixon actually thought, I'd rather leave office voluntarily, which is exactly the same result as being impeached and convicted. I'd rather leave on my own than have them find me guilty of some high crime or misdemeanor. So maybe there is some reasons for thinking perhaps we could do that. We should do it. It's never come up, but what the hell. Presidential pardon power. Is everyone all right with this just real short introduction? Yes, sir. It has to be simple because I won't be able to help you otherwise.
And not convicted, can you come back later and impeach him?
Oh, sure.
And try to convict him?
Yes, I assume you'd have to. I assume you'd have to have. If I were demented to the tune of. Yes, and in fact, Gerald Ford said when someone said, "You're going to try and impeach William O. Douglas? What are you trying to impeach him for?" And he said, "What constitutes grounds for impeachment and conviction is completely determined by the U.S. Congress." So yes, you could, whether you'd have to have, there's nothing in this that says principles like double jeopardy over the same transaction and occurrence or the same set of litigating facts would prohibit someone from redoing it over again. I assume there's no principles of res judicata or collateral estoppel that would stop it. So I think you probably could do it. I don't think you'd get away with it. But if you had other grounds to supplement what you just lost at, then perhaps you could do it again. New evidence, right? It was hidden. It wasn't our fault. We showed due diligence in looking for this. Are we all right? Anything else? Anything at all? All right. Well, then if you look at presidential pardon, we should look at this because, I should read it to you if I may. The Article 2, Section 2, Clause 1. And this is all it says. It's on page 14 of your handout. It says at the end of the first paragraph, and he shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Aha! Well, I have one exception then. You cannot you cannot pardon someone who is going to go through impeachment. Impeachment proceedings have been initiated, then I assume because you've engaged in an infraction of some sort, a high crime or misdemeanor, then you cannot be pardoned from that proceedings. But I think the first I would try and distinguish would be the greater lessers again. What is a pardon? Well, a full pardon, according to the United States Supreme Court in Ex parte Garland back in 1866, the Supreme Court said, when you receive a full pardon, you're not only not found guilty, you don't have a crime. You haven't done a crime. And not only have you not done a crime, you are also restored of all of the civil rights you would have lost otherwise. All of them. Couldn't vote yesterday? You can vote now. Couldn't hold public office yesterday? Well, now you can. You could hold public, all of your civil rights are restored. The court used the phrase, restored status quo ante. Whatever the status quo that you had before the crime for which you are pardoned, you would regain. Well, if a full pardon, if the president is entitled or has the authority to grant a full pardon, then surely, don't call you Shirley, I know, surely they would be able to, what? Postpone an execution or postpone a penalty. Isn't that a reprieve? Right? Postpone it. Or they could commute, lessen the penalty that you suffer. Scooter Libby was what? His sentence was commuted. Right? And the president had the authority to do so, George W. Bush. Right? Are we all right with that? Okay, so thank you. Pardon, what's the difference between a pardon and amnesty? Well, pardons are generally particular, right, to a particular person, or they're more specific. Amnesty can be specific as to what is being covered, but the people who benefit from it is generally very large, or at least larger than the normal specificity of a pardon. It also, in the beginning, it was also thought that a pardon had to be accepted, or at least not rejected, and an amnesty didn't have to be anything at all. In any way, you could move on it or not, accept it or not, it didn't matter. Think of what are called unilateral contract offers. Someone comes to you and says, oh, by the way, I have a reward out for anyone who finds my dog. They will laugh at you if you say, well, I accept that offer. That you can only accept with a unilateral offer by performing. Find the dog. Right? You just can't go in there and bind yourself and bind the offeror. That's by accepting, by that way. So the only thing an amnesty does is so very much like a unilateral contract offer. Whoever can perform properly, they have accepted the contract offer. Find my dog. That's the reward, right? Amnesty did not have to be formally accepted. But in a case called Burdick in 1915, the president offered the defendant, Burdick, a pardon, a full pardon. And he said, no, I don't want it. And they said, why don't you want it? And he said, because if I accept that pardon, then you can't prosecute me for that crime. That you couldn't do again, right? So you would have Fifth Amendment double jeopardy implications. And if I can't implicate myself when I in fact testify, which would then allow me to raise my Fifth Amendment so that I wouldn't be forced to testify. Now, if I'm pardoned, good grief, I can't incriminate myself. And you could then force me to testify. And if you do that, if you do that, what will happen is that I'll incriminate all my Confederates. I'll incriminate everyone. And I don't want to do that. So I reject the pardon so that I can't be forced to testify against any of them. Notice, in 1915, that makes perfect sense, to Charles II, who was accused of treasonous behavior by engaging with the mortal enemy of Great Britain, France, And what did he do to stop himself from getting in trouble? Was simply to pardon all the people that were his emissaries, his agents. He just pardoned all of them so that they couldn't lead up to him. Who took that as a model? George Herbert Walker Bush. With Iran-Contra, that's exactly what he did. I'll pardon all of them, and when I pardon all of them, they won't come and get me. Well, of course, if they're all pardoned, now they could be, through compulsory process, put on the stand and made to testify, and they couldn't yell, by the way, I refuse to testify because I'll incriminate myself. Interesting. It just didn't happen to George Herbert Walker Bush, but it might have. Are you all right with all that? By the way, is that the same principle that works today? No. Oliver Wendell Holmes, in a case called Biddle versus Pervovich, in 1927, the court held that it's also a public right. That is, the public has a right to have people pardoned, and it doesn't matter whether those individuals accept the pardon or don't accept the pardon. They're pardoned irrespective. And the reason for that, and you know that's from Gerald Ford's reasons for pardoning Nixon, at least his last reason, was that, in fact, isn't it true that this will heal the nation? If you don't pardon Richard Nixon, then what? America will be concentrating on all of the crimes that the federal government will be prosecuting him with. We don't want that. Congress will come to a stop. We'll have back then what we have now. An immobile contract. You're not finding any of this funny, huh? We'll have a Congress that is immobile, can't do anything. Does that make sense? So we don't want to do that. To heal the nation, we're going to immunize President Ford.
If you pardon, you have to pardon against all crimes committed. In other words, when you have partial pardon someone
Pardon can be
what they did as an official act.
a pardon can be specific, very narrow, and it used to be always that, or it can be broad. In fact, if you'll hang on for a second, when I get to self-pardons, you'll see how that started, and only could have started, because of what Gerald Ford did with Richard Nixon. But hang on and see if it answers that. So I have what the pardons are, both for purposes of public and acceptance and non-acceptance. Pardons and clemency, well, clemency power is just the general term for pardons, reprieves, commutations, and the like. It's used synonymously. So all I need now are just to specify the conditions for pardons before we just look at some of the arguments. So let me see if I've got this right. It said, remember, a federal offense. So that means it does not include the state. New York, whether it's false bravado or not, New York says the minute Donald Trump leaves office, we're going to prosecute him. There's Trump University, there are all those contracts on his buildings, breached contracts, zoning codes that have been butchered, we're going to prosecute him. I don't know that they will, but they could. The only person who could not prosecute with a self-pardon, not prosecute Donald Trump would be the federal government. And it's federal offense. What is an offense? Well, it is a public breach. And that would mean it's a criminal act. So these are crimes that are going to be pardoned, federal crimes that will be pardoned, not state crimes. But there's a scholar, a constitutional law scholar. His name is Erwin Chemerinsky. He's the dean of the law school at Berkeley. And he is the one with Sheriff Aprile, who argued that Donald Trump could not pardon Aprile. And he couldn't pardon Aprile because Article 2, Section 2, Clause 1 says federal offense. What is an offense? Offense is a violation of the law, And in this case, it would have to be federal law. And who makes federal law? I know that the courts read federal, construe federal law, but who makes federal law? Pardon? Congress. Congress makes federal law. And so when they talk about offenses, they're talking about federal law's violation. But Aprio was suffering and was pardoned for, suffering from and pardoned for criminal contempt. For what? Engaging in invidious kinds, ethnically invidious kinds of stoppages in investigations. He was told to stop. He said, put it in your ear, I'm not going to stop. And there was an order, a contempt order leveled against him. But criminal contempt is not from Congress. It's an inherent power of a court to enforce its own orders. When the court says, stop doing that, and you say, I'm going to do it anyway. Well, when they produce a contempt order, right, a criminal contempt order in this case, right, the criminal contempt is just the inherent power of a court. It's not an offense. It's an infraction. It's a federal infraction. But not all infractions are offenses. Offenses are not the sort of thing that Aprio did. He engaged in an infraction. And Chemerinsky, Professor Chemerinsky, or Dean Chemerinsky, argues that this was not appropriate for a pardon. It fell outside the scope of appropriate pardon power. It went to the federal district court, and Judge Susan Bolton said, oh, that's, you academics. And so she didn't find in favor of it. But nevertheless, she was entertained, I take it. And we have the one exception is, again, impeachment. Are we all right? So the only thing to do, I think, are to go through the arguments about self-pardoning. However, consider for a second. Before Gerald Ford pardoned Richard Nixon, pardons were tied to indictments. So pardons were specific, right? And they were post-indictment, post-charge. And so, think, who the hell can give who the heck can issue a pardon? The only people who can issue a pardon is the chief executive of every sovereign. So I take it governors can and the United States president can. And we're worried about the latter. The president can. The president, according to Article 1, Section 3, Clause 7, can't be indicted in office. You have to wait. Get rid of them before you indict them. If I couldn't be indicted in office, and I couldn't get a pardon until I was indicted, then I couldn't issue my own pardon. I wouldn't be able to do it. I don't know what the heck I would be doing it for. When Gerald Ford gave a pardon to Richard Nixon, he hadn't been indicted. And it was for all crimes associated or rising from the Watergate break-in. All of them. Whatever they are. I don't know what they are because I'm doing this prior to an indictment. Now it makes sense to look for a self-pardon. I don't have to wait for an indictment if this was pre-indictment, and I don't have to wait for anything specific. I can say anything that arises out of. By the way, is there a ramification from this? Yeah, before Ford's pardoning of Richard Nixon, right, this wouldn't have made sense. And the first president to ever do it was George H.W. Bush. And he did it in 1989, November 17th. This only makes sense if we just followed together. We were just dancing together about what I just said. It doesn't have to be tied to an indictment. It doesn't have to be specific. He pardoned, literally, under Article 2, Section 2, Clause 1, the Thanksgiving turkey. I didn't even know the damn things did anything wrong, except get fat, right? I didn't understand it doesn't matter now. Other presidents may have refrained from eating the overstuffed bird, but only George Herbert Walker Bush pardoned it. But now that makes sense. But only it makes sense after Ford. It would have never occurred, I assume, unless they were drunk or on drugs, that a president would have figured doing that with a turkey before Gerald Ford did it with Nixon. One of the serendipitous effects of Gerald Ford's attempt to do this. All right, so let me try and do these other ones. Can you self-pardon yourself? Well, let me try the silly argument first about in favor of it, and we'll see if this works to you. The chief executive is also the chief prosecutor. I think the Department of Justice is under the president. I think the Attorney General is under the president. Is this right? Well, as the chief prosecutor also enjoys a certain, what? Ability. What is that ability? I mean, besides being a jerk or something. They have the ability to engage in prosecutorial discretion. They don't have to prosecute if they don't want. Right? Even after a true bill has been issued by the grand jury and the true bill has been given to the prosecutor, does the prosecutor have to indict on the basis of it? No. And when people have argued and got to the Supreme Court said no. The prosecutor does not have to act on it. The prosecutor cannot act without probable cause being determined by a grand jury, but a grand jury doesn't determine, it's not dispositive of what the Attorney General or in any given prosecutor would do. They don't have to. They have prosecutorial discretion. Well, if the chief executive is the chief prosecutor, isn't it possible that the chief prosecutor could say, I'm not going to prosecute myself? Is that like a pardon? How many fingers am I holding up? Does that make some sense? If that's true, then it's easy to justify self-pardons because the chief executive is the chief prosecutor and always has discretion as to whether or not to prosecute. The problem with that, I think there's a problem with it, is that whatever a prosecutor does on Monday does not tell me, except when I've run the statute of limitations, doesn't tell me what the prosecutor is going to do on Tuesday. That a prosecutor says, I dismiss the charge. They can always say, I'm going to dismiss the charge without prejudice, which means what? I could bring it up again. I could bring it up tomorrow. As long as I'm not trying to harass you, I can keep bringing it up. And up and up and up, until I hit the barrier of the statute of limitations. Some of them are turned by a year, 6 years. Some of them, there is no statute of limitations, murder, right? So it's true they have this, but a dismissal or a refusal to prosecute doesn't have any double jeopardy implications. But a pardon does. You get pardoned, and that's the end of that matter. There is no prosecution upon the pardon. The pardon ends it all. So I have a weak analog for a primary subject, and it's not deductively valid then. I mean, this one is too weak to justify the pardon. We all right? I think so. That's one of the problems with it. All right, so try it again. If you look at, remember, Article 1, Section, what is it, page 14? That'll stay there. Article 2, Section 2, Clause 1. Watch what happens here. And this is the strongest argument for it not doing it. That is, that the president can arguably pardon him or herself. And he or she shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Am I supposed to read that as one of many exceptions? Or am I supposed to read that as the one and only exception? Is that list of exceptions illustrative? Here's one example. Or is it exhaustive? That's it. Plain meaning from here won't tell me how to read that. But I can bring in, and they do, an argument from canon law, well, they're called statutory and constitutional canons, about how to read statutes, how to read constitutions. And it says this, and I have it in the Latin. DeLoss could read it for us in the Latin properly. I'd screw it up. And the way it reads is to make an exception, or to list an exception, or to list a condition and nothing else, is to excuse all the other conditions. So the way I would read this is, I have one exception. The framers were not idiots. They were thoughtful, intelligent individuals, and they sat down and said, well, here's the exception. And they could have written, here's the exception, and etc., or here's one exception at least. They didn't say that. They said, here is an exception. So when I don't have anything else, I use the canon to help me to figure out whether or not I should read that list as exhaustive or illustrative. And with the canon supplementing plain meaning, then I come up with, that's it. That's the only one. It does not say self-pardon. If it doesn't say self-pardon, then you can do it. Does that sound reasonable? Intelligible? All right, well, that's one. That's the strongest argument. And so what about the arguments against it? Well, you'll see that most of the arguments against it attack not the prosecutorial chief executive argument, but they attack they attack the strongest argument for by trying to show that all of those exceptions shouldn't be read myopically, and according to that canon. It should be read expansively. And why would it be read expansively? Because there are other kinds of things the president can't give pardons for. I mean, Chemerinsky tried to argue, which is different, that something didn't constitute an offense. But they're going to argue that there are other things that tell me that I shouldn't read that list as just one. So let me do the first one, but these aren't exactly in order for this. So let me try this. Let me try number one, the ordinary language argument. And it's this. Remember, the president is able to grant a pardon, reprieves and pardons. Grant, but the president already has it. This is Lawrence Tribe, a professor emeritus from Harvard Law School. This is his argument. I'm not sure I have trouble making sense of it. But his argument is the president has that inherent power to issue pardons. If he has the power, he couldn't give it to himself because that would give himself something he already has. It would be analogous to this. I can't try to stand up right now. I'm already doing it. Right? I can't try to move my mouth when I talk. Wittgenstein, I think. Right? I can't do it. I could pretend to be you, But I can't pretend to be me. I don't know what the hell that would mean. I can't give myself something I already possess. Sound weird? It sounds like a confusion, doesn't it, in a way? At least it struck me that way. And I thought the confusion was this. The president, in the official capacity, has an official liberty to issue pardons. The person who receives a pardon is not an office. It's an individual. Thinking it's in this case, right? It would be an individual. Giving Trump a pardon is to have the office of the presidency, in which, that's a predicate nominative in this case, right? He is the president, giving Trump, the individual, a pardon. Because the pardon only occurs after you've left office. I don't mean you can't be granted it, but in this case he would, but it would only become activated, so to speak, spring into action after. Right? When I get sued by an individual because I have violated their federal rights, I get sued under a statute, volume 42 of the United States Code, 1983. You've probably heard of 1983 suits. 1983 suits can be in two forms, and simultaneously. They could sue me in my official capacity and my individual capacity. If a statute can do it, isn't that what's happening here? The difference, the confusion between the ability to give a pardon and to execute one, or to have it materialized or actualized. Does that make any sense? It does? How cool. One person said yes, and so I'm going to generalize that which is what I do at school. When people just stare at me, I usually take that as a standing ovation. All right. Number two. Here's another. This is another Professor Tribe argument. Article 1, Section 3, Clause 7. What was that? Oh, I remember. It's over here, wasn't it? After impeachment, you will be nevertheless be liable and subject to indictment, trial, judgment, and punishment. Well, that must mean that you can be what? Criminally prosecuted, which must mean you weren't pardoned. But that's wrong, isn't it? This just says you can be what? Criminally prosecuted if you haven't been pardoned. If I'm pardoned, if I could pardon myself, I definitely wouldn't be criminally prosecuted. Correct? So this presupposes you've never been pardoned. If you're pardoned, you won't be prosecuted because you're pardoned. In fact, I thought Richard Nixon was never prosecuted because he was pardoned. Right? Even if he had been impeached and Ford had pardoned him, the pardon wouldn't be vacuous, it wouldn't be perfunctory, it would have been what? Effective. Right? So that argument sort of assumes something that needs to be demonstrated and hasn't, I think. Are we all right? Those two don't sound altogether that great, I don't think. But how about these? The number 4 and 5 are very similar. And this is by Professor Amar, who is a professor of law at Yale Law School, a very prolific writer and a very important one. But he argues, if you look at Article 1, Section 6, Clause 2, what it amounts to is telling you that Congress could not do this. I'm going to create a federal office, and I'm going to give it lots of money, and then I'm going to quit my job and run over there and take advantage. You can't do that. You'll have to wait for an ensuing, if I'm not mistaken, election. In fact, that is exactly the same thing on the 27th Amendment right? If I can get this thing. The 27th Amendment says, no law varying compensation for the services of senators and representatives shall take effect until the election of representatives has intervened. The 27th Amendment, the very last amendment that was introduced in 1789, passed in 1992, was that you cannot, give yourself a raise and immediately enjoy it. You'll have to get reelected. Now, I grant you, the Senate gets a little bit of a pass on that, but the House of Representatives won't. They have to get reelected. And what is that all supposed to stop? I think it's supposed to stop, isn't it? Conflict of interest. Right? A conflict of interest. A conflict of interest is exactly what pardoning yourself looks like. Don't I enjoy something at my own hand, as it were? Am I not just benefiting myself rather than the nation? That conflict of interest is disallowed. Is that a good enough argument to demonstrate that self-pardoning should have been added to this as well, or is implied by this? And the problem with that is that isn't that just exactly why there is expressed statements in here? Notice I referenced not implied, but actually express Article 1, Section 2, Article 1, Section 6, Clause 2, and the 27th Amendment. I offered literal, statements that prohibit self-dealing. This is about what? No express statement about self-dealing. And since people are purists and they like separation of powers, these two represent what? The real, not the only real, but the real political branches called Congress. This is about the executive. The executive has all sorts of abilities that Congress doesn't have. And there's all sorts of dangers with Congress that maybe the executive doesn't face. So there's a disanalogy there, a little. I'm not sure it's strong enough to pull along the self-pardoning prohibition. All right, let me try another one. Could the president give pardons on the basis of racial animus? I'll give pardons to European Americans, but not to African Americans, not to Native Americans, not to Asian Americans. Or I'll give pardons, but only to women. I'm not going to give any to men. Could you do that? Could you give a pardon as a bribe? Thomas Jefferson has at the impeachment trial of Aaron Burr. Remember, Aaron Burr is the guy who was the vice president, the willing and unwilling vice president of Thomas Jefferson in his first term of office. Remember, he was only that because Thomas Jefferson and Aaron Burr kept having a tie in the House of Representatives, and when who pushed the vote away from Alexander Hamilton away from Aaron Burr was Alexander Hamilton. Alexander Hamilton then, when challenged by Aaron Burr for why you were such a scurrilous cad, he corrects his grammar and tells him what kind of better letter he could have written Alexander Hamilton. Alexander Hamilton gets upset and says, why don't you meet me on the plains of Weehawken, New Jersey, which of course there are no plains in Weehawken, New Jersey today. Hell, there's no real New Jersey today. But what isn't it, just what off-ramp do you live on? And that's how they determine where you live in New Jersey, on the New Jersey Turnpike. The individual, Alexander Hamilton gets shot right? Aaron Burr leaves the country because now they're trying to arrest him for killing Alexander Hamilton, former Secretary of State, and he then is accused of treason by trying to get Western states together and have a separation, if you will, from the United States. Remember? And they do all of this, and what does Thomas Jefferson do? Don't forget, Thomas Jefferson had a cousin whom he hated, and his cousin hated Thomas Jefferson, and that was John Marshall, Chief Justice of the United States Supreme Court. This is a family that didn't overachieve, right? This is Alexander Hamilton's killer being tried for treason in the United States Senate, and Thomas Jefferson allegedly ran around saying, if you will testify, I'll give you a pardon. Notice, it's exactly the opposite of what George Herbert Walker Bush was doing. Not, I'll give you a pardon so you won't testify. I'll give you a pardon if you will. If you testify, good grief, I'll give you a pardon. You won't be able to implicate yourself. He was using it, according to his detractors, as a bribe. Can you use pardons as a bribe? Not all at once. Good grief, I hate it when you all talk together. Notice there's another description of this, right? I gave you a pardon so that you could testify. Issuing pardons to promote testimony is not necessarily a bribe, right? In fact, I think people do it all the time today. Oh, we call it immunity, don't we? You won't testify? I'll give you use immunity. Testimonial and use immunity. Now get on the stand and talk. We do it all the time. I mean, the proverbial prosecutors, do it all the time, correct? So there's a way of describing this so that it's not a bribe. But second of all, what about the racial animus? Again, don't I already have that in the Constitution? It's called the Equal Protection Clause. But wait a minute. I can racially discriminate. And I can discriminate on the basis of gender. All I have to do is prove or satisfy the proper, judicial scrutiny. If I want to discriminate on the basis of race, being the governor, or being the president, or the government, I'll have to demonstrate a compelling state interest and that this is the least restrictive, narrowly tailored way of doing it. I'm free then. To say you're being racially discriminatory for the government, for the law, is only the beginning of the conversation. Because the Equal Rights Amendment failed, I could do it with gender. Right? And all I have to do there is not prove a compelling state interest. All I have to do is show an important state interest. And with an important state interest, that this is narrowly tailored to achieve it. Right? So, I mean, I can do that. But notice this, I think. By the way, those were already written, and they're written to cover everything. In a case called Schnick versus the United States, 1974, the United States Supreme Court said, if you're going to find an exception to pardon, you better find it in the Constitution. Now, that the Article 2, Section 2, Clause 1 does not say, oh, by the way, you cannot racially discriminate, or discriminate on the basis of ethnicity, or discriminate on the basis of gender, does not mean that it's not already in there. Correct? In fact, you don't have to repeat the damn Constitution with every provision in it. Isn't that true? It's already implied. In the Supreme Court in 1974 said the U.S. Constitution is a consistent document. That means there's no inconsistency in there. And if you find one, you'll have to get rid of it. You'll have to construe it away. That the Article 2, Section 2, Clause 1 comes in the mass of an entire group of rights and obligations. Doesn't mean that the list that they gave is more expansive. Correct? Also, you know, the the conflict of interest. Are we all right with it? So what we've gone so far? Well, the conflict of interest is even more pronounced. But what if remember I said the conflict of interest before was with, Article 2 versus Article 1, Congress versus the executive. But wait a minute, isn't there a statement, a judicial canon again, that says you cannot be the judge, the prosecutor, or a jury member in your own trial? Isn't that true? If the Lost weren't so shy and reserved and retiring, he would pronounce this for us. Nemo judex in casa sua. You're laughing. That means I mispronounced the hell out of it. But I mean, what it's saying is that, you cannot be a judge in your own case. Number one, you can be a judge in your own case, so to speak. Although these cases were classified under that when the Supreme Court said you can't do it. Toomey versus Ohio, 1927, the Supreme Court said, wait a minute, there's something wrong with a neutral magistrate who receives a salary from traffic violation fines, when all the traffic violation fines come up before that judge. All of them did. Can you guess the outcome, guilty or not guilty, of all of the traffic violations? Yeah, they were all guilty. And his per capita income increased dramatically. Another one, I think it's Caperton versus Massey, 2009. In that case, Caperton is a coal company, Massey is a coal company, and Caperton had accused Massey of tortious interference with a contract. And misrepresentation, fraud, a massive number of things, and at trial, Caperton prevailed, Massey lost. The CEO of Massey then went out and started, what foresight? He started to campaign for a Supreme Court justice for the West Virginia Supreme Court, of which there are 5 members, and they have 20-year terms. Right? So he goes out campaigning for him. Well, not just that. He supplies a massive amount of money. And also, by the way, Massey appeals the lawsuit they just lost. It goes through the West Virginia system. It ends up before the West Virginia Supreme Court, and good grief, the guy they wanted, some guy named Benjamin, he's on the court. And what does he come out with? 3-2. with Benjamin arguing, reverse that judgment. Now, they appealed. They appealed it to the United States Supreme Court, and the Supreme Court, there's more to it than this, but the Supreme Court said what? Well, if you can't be a judge in your own case, you can't pick the judge in your own case, so to speak. You can't be the appellate judge in your own case. And that's what they did. So maybe that will work here. This is the most popular argument about both Amar and Tribe and every other academic scholar I've read that is in favor of putting curtailment upon President Trump. All come up with the same argument. You can't be a judge in your own case. People who never studied law that I've talked to have said, you can't be a judge in your own case. Isn't that what he's doing? And there are 2 things. Of course, you can be a judge in your own case. Gore versus Williams in 1920, and then Miles versus Graham in 1927. The issue was, do federal court judges have to pay federal income tax? And you'd think, yeah, of course they do. Well, not initially, not with Gore, not the Gore you're thinking of, but the Gore back in 1920. That case said, no, you don't have to, because there's a provision in the Constitution that says the salary of a United States judge cannot be lowered. And this lowers it. And in the 27 case, the Supreme Court said, oh, we were drunk. We were sorry. We didn't mean that. What we meant is that your gross salary can't be lowered. Your net salary can. Does that seem reasonable? But all through that, the Supreme Court was painfully aware that they had a vested interest in this. Don't they? Yeah. And so what did they argue? They said the doctrine of necessity will allow this. You will allow this because who else is going to adjudicate this? Congress? Congress can't do anything. The president? The president has political affiliations. No, we'll do it. Yes, we have to. So you actually can be a judge in your own case, broadly drawn the way Toomey and Caperton draw it. Right? But there's one worse problem. I think it's worse, at least anyway, and that's this. This isn't adjudication, is it? This is a pardon. This is a circumvention of adjudication. If you went to trial, you shouldn't be a judge in your own case. That's true. You shouldn't be the prosecutor in your own case. You shouldn't be a jury member in your own case because you'll hang the jury every time. But this isn't about the judiciary. This is about Article 2, the executive circumventing the judiciary. This isn't about trials at all. It's a legerdemain. It's argumentative legerdemain. They're just shifting, they're moving pea pods around or something. Right? I mean, it's just stealthy to argue this. It's the way your dentist got you to what? When you were a kid, and you thought, what are you doing to my cheek? And it was what? To distract you while they took that hypo and stuck, wasn't yours that long? Does that make sense? All right. Well, do you have to do this? I've already explained President George Herbert Walker Bush to you. So that's a false start. But how's this? I have number 2. You would never even know it. What if the president did this? This is President Trump. I pardon everyone associated with illegal associations with Russians. That would be a self-pardon, wouldn't it? You'd never know it. At least you would know it, but lots of people would never catch it. Correct? If you give general amnesty to a group of which the pardoning individual is a member, that's a self-pardon. I mean, Richard Nixon, if he had just thought through this, might have said, I pardon everyone who is associated with Watergate. He'd have been pardoned. There's the danger of not catching this, I guess. But let me do the more intriguing one. I think it's more intriguing, but I don't know. It's because I'm not married. Maybe that's what it is. Life looks much more piquant to me because I don't have anything piquant in my life. The National Vote Compact. The National Vote Compact took if you read it, Article 2, it takes the Electoral College and it says that you will never again suffer the election of a president when the popular vote of for that individual is not sufficient to actually win the Electoral College on a purely representative model. It would take these states that have agreed to this, there are 165 electoral votes involved that have already been committed, need 270. The minute that 270 are reached, they will not do things the way they have been doing them. And the states are big states, New York, California, Washington, Illinois. Michigan is considering it this year, and so is Pennsylvania. And the argument is this: instead of having your legislature, which according to Article 2 is the state legislature determines where the electoral vote will be, how it will be cast, instead of having your legislature cast the vote in terms of who won the popular vote in your state, they will now cast the vote who won the popular vote in the nation. I have just circumvented the Electoral College by using the Electoral College. Every Congress has a movement to amend the Constitution to get rid of the Electoral College. It never goes anywhere. but there's always movement. Now, I don't have to do that. I'll just use the damn thing to circumvent it. Does that make sense? Okay, so it just occurred to me that you could do this. Well, it just didn't occur to me, but it did occur to me. On page 21, it is the top. It's the 25th Amendment. Passed, introduced in 1965, passed, ratified in 1967. And it says this, Section 3. By the way, before I read this, people have said that Bill Clinton could have better ensured the election of Al Gore if he had done this. Whenever the president transmits to the president pro tem of the Senate and the Speaker of the House his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting president. So this is what Al Gore could have enjoyed if Bill Clinton had thought to use this article, Section 3. He could have said this after his first term, third year. He could have said, "Hi, I'm not capable anymore. I've got to take a break." Al Gore becomes the acting president. Al Gore runs for election as an incumbent, wins, picks Bill Clinton as his vice president. On his third year, he then says, "Holy cow, I can't do this." Bill Clinton becomes president, and instead of having Al Gore and Bill Clinton for 8 years, you could have had Bill Clinton, Al Gore, Bill Clinton, Al Gore for 16. Tony Blair, you must have heard, Tony Blair and Gordon Brown in Great Britain for the prime minister. Oh, did they not? Didn't you just constantly hear them? Don't these people die? How do they ever leave office? That's what they did. And they did it with a gentleman's agreement. But they are British. Oh, I guess that makes sense, right? Are we all right? Okay, I could use this. Does Donald Trump have to do this? Have to issue himself a pardon? No. He goes in and says the following. I can't, to the Senate and the House, I can't do this anymore. I need a break. Make him, Pence, my vice president, president. Acting president. As acting president, he has all the rights and duties. The first thing he does when he takes office is pardon Donald Trump. Donald Trump recovers immediately. I'm ready to work. Let me have it. Hasn't Donald Trump actually achieved a sort of self-pardon through what? A non-contumacious, obedient vice president? Isn't that true? I don't have to self-pardon. Hell, I've got the ticket to do it right here, don't I? Don't you think? Yeah, it's just another way of using the Constitution in a way that was not anticipated. Are you all right? Hello? Are you out there still?
I have one.
Sure.
I don't know if you're implying or not, but what has Donald Trump done to you?
It's not that he has done anything for which there is sufficient evidence, but his alleged associations with with Russia is what people have said he could be criminally prosecuted for. Some people have said it's treason. Could he pardon himself? Donald Trump, on his own, through tweets. Oh, really? Tweets said, I could pardon myself. And that's when the whole discussion started. And that discussion about whether he could pardon himself was taken initially as, boy, we've never heard this before. It's been around since since Richard Nixon, actually. But nevertheless, that's what he said. Well, hell, if you don't like what I've done with the Russians, you try to get me, I'll pardon myself. There is no federal crime, even if it's treason and you want to impeach me.
He implies that he thinks he may have.
Yeah, but see, that I don't know, because I can't, anyone else, I would have thought, yes, anyone else, I would have thought that. I don't know whether he was saying this. This is a joke, but anyway, I'll have some fun. I don't know what I don't get it. I don't, I'm sorry. All right, are we all right with this? What could I do to try and address some of this? I mean, what's called the concerns could you have? Well, you could make self-pardoning an impeachable offense. Pardon yourself, you're going to get out of here. So when Donald Trump or any other president ends up pardoning himself or engages in subterfuge to achieve the same thing, maybe you could have that as an impeachable offense. The problem is what we just talked about the same thing, even it has the same effect, with an obsequious vice president? Would it chiefly amount to a functional self-pardon? If it does, then you might still be able to impeach, but if you didn't, it wouldn't be impeachable, I guess, unless you wrote the statute broadly. That's one. The other one is this.
Did Bill Clinton commit
He was impeached, but he was not convicted.
Yeah, but did he commit a criminal act?
Oh, yes. Perjury.
No, had an affair as a criminal act?
Perjury. Yes. Some people mistake that because they're so tied together. Adultery and perjury. You do one, you've done the other one. Yeah, I know. But the other one is a philosopher.
In that case, Trump is in big trouble.
Has he perjured himself or just adultery?
No.
He's lied perhaps to his spouse, but nevertheless, I don't know if I don't know if he did that with an oath. The other one is a philosopher who has written something on this topic and said that the way to stop this would be to make the self-pardoning illegal. So you would have done something that would cause you then to, what? Pardon yourself, so you couldn't be criminally prosecuted. And the minute you did that, you did something illegal. So what would be your first response? Then you'd pardon yourself again. And then that would itself be illegal. And then you'd pardon yourself again and pardon yourself. And in the end, you'd come to the end of your term, and there'd always be one last, what? Unpardonable crime. And that was the last pardon, self-pardon that you engaged in. Are you confused? That was my goal. May I answer any questions? That's what I wanted to show you or demonstrate. Yes, ma'am.
I think I know the answer to this. Is there any way to unpardon a president who has pardoned himself wrongly?
What is wrongly? Well, notice it says what part, it doesn't give a criteria for it. I mean, I don't know what wrongly would be, unless you're going to say that it was based on things that violated other areas of the Constitution. For instance, it was racially, genderly, it was ethnically biased or something.
Suppose the House already has, or had, suppose the House had a list of impeachable offenses which a president had committed.
You couldn't pardon that at all, anyway. Remember, impeachment can't be pardoned.
Is there anything that could be done to correct an erroneously pardoned president?
There's nothing in the Constitution that gives me restitution or remedial action at law for what would be arguably, whatever that might be, a non-pardonable pardon or a non-justified pardon. It's almost by fiat whether or not you can pardon someone, right? Unless you were doing it this way, had Judge Bolton found that a prio had committed not an offense, but merely a federal infraction, then the pardon would be void. I'm not unpardoning a pardon, but you would void one, yes. In that case, it would have, but she didn't find that. Of course, but I thought you meant like something, you know, we didn't like the ramifications of it or something of that sort. You are just like my students, yes, sir.
I've got a question that doesn't really pertain to the topic at hand. Can I ask something in general?
I don't know how flies land on the ceiling. I've tried to figure that out myself. I thought, you know, at first that they must just flip over as opposed to do loops.
Whenever the Trump administration performs some type of act for which a group dislikes, they seem to be able to shop around to a state that finds it unconstitutional. Why does a single state, like the District Court of 9 in California, seem to have the power of overruling something in the entire country?
On that, you're doing what Jeff Sessions was arguing about. How does a trial judge set precedent? Well, they don't. They can't. And it is extremely odd. But it's, I mean, the odd it is that their limited jurisdiction wouldn't permit it. However, if it's a circuit, right, the 11th Circuit, whatever the 11th Circuit's done, holds, is the law for the 11th Circuit, at least, and they can refer to themselves when lower courts are adjudicating that same issue, right? That the 11th Circuit has found this, so long as it doesn't contradict anything the United States Supreme Court has done. So the 9th Circuit is a giant one, and that giant circuit serves as the precedent for non-United States Supreme Court stare decisis in that circuit, and that's all. But you know, even Jeff Sessions said, I don't know where this came from, this notion that a trial court judge, it was a district court judge too, said that it's unconstitutional across the country. And other district courts said, no, it's not. We're not following it anyway.
So who decides what's constitutional?
I'm sorry? Oh, well, it's already decided. It is the Supreme Court. I mean, that's how federal courts are created. In Article 3, there's only one court that is established by the Constitution, and it's the Supreme Court, right? And then, by the designs of Congress, they can create all of the other lower federal courts, each with their own geographical jurisdiction. And it takes an act of Congress to create another, like for instance, the 11th Circuit out of the former 5th Circuit, right? So that's their jurisdiction. One would say this is sort of ultra vires. You've gone beyond the scope of your authority when they do things of that sort. Yeah, so I mean, lots of people have said, well, Jeff Sessions is not wrong here, notwithstanding. This Jeff Sessions. I'm joking. Yes, ma'am.
What about just an opinion of the popular vote versus electoral college? How seriously do you think that would be?
There are two things that run against it. Article 1, Section 10, Clause 1, which says you cannot have these kinds of arrangements at all, irrespective. And one of them is a confederacy. Right? But in Article 10, Article 1, Section 10, Clause 3, it says you can't do it unless Congress approves. One of those is a compact. Did Congress ever approve this? Well, in 1978, it was called the United States versus the Multi-State Tax Commission. Multi-state being it was a compact for taxes. And the United States Supreme Court said, this is, most people would say, I knew they were going to do this. It said, I know what that statement says, literally, but that's not the law. The law is this: we presume that they accept it. And it's only when they bring forth an argument or demonstration, when Congress does, that the compact giving power to a state, giving power to states, that takes away or steals from the federal power. If it's not doing that, then it doesn't violate the Multi-State Tax Commission case, its notion of what constitutes a violation of Article 1, Section 10, Clause 3. Does that make sense? And so, what are the chances that it will survive? Looking at the popular vote surely doesn't take any power away from the federal government, right? Nor does it take, the only thing it takes power away from, I assume, is that there's something called the state out there that could trump or supersede or preempt the power of the populists, right? And the benefits of the national popular vote, which they claim are many, is that there'd be no states that are just ignored. Alabama is ignored all the time, and it's ignored because even Nick Romney said, this is an away game for me. Romney said that? And so the idea is that if you had people voting and they were counted, as opposed to states ultimately being counted, then politicians would go everywhere and they would talk to everyone in order to pull forth a democratic oligarchy each 4 years. I'm joking. Does that make sense? The oligarchy part doesn't. I mean, I'm joking about that. No, I'm not. That's what John Adams said, actually. Americans vote every 4 years to create a 4-year-long dictatorship.
There is no federal rule of how the states petition their.
No. That's why you could have a compact that would allow that. People are dropping like flies. Are you all, may I answer anything else? Anything else? No? Well, thanks a lot for inviting me. It was fun. Thank you, I appreciate it.